Hello, everyone. This is Ifama Odulami, immigration attorney from the Odulami Law Firm. First of all, I'm going to say that my computer on Facebook is a little weird. So it looks a little blurry because I got a third monitor and somehow it's just not working and affecting this monitor that I use for my Facebook. So pardon me for that. We'll get that checked out. But on Instagram, I'm looking clear. Hi, everyone on Instagram. Hi, everyone on Facebook. I hope you guys had a great weekend. I did. So here in New Jersey, it was hot, hot, hot. And I guess after having, after going through winter and just rainy days, it was kind of nice, to have a really warm day. So today, I have a really, really great topic for you guys. And I've talked about this before in the past, but I want to come over, go over it again because I have people who come for consultation and they're asking these questions. And so I figured I should do this live. So listen on and let's get started. As you know, or for those who haven't met me, my name is Ifama Odulami. I'm an immigration attorney from the Odulami Law Firm in New Jersey. But my law firm serves clients in all 50 states and even abroad. So if you have a family-based immigration matter or you have a humanitarian-based immigration matter, call us where your people will help you. We're immigrants in this firm, and so our passion is helping other immigrants. And don't forget to subscribe and like so that when I come on, you get information right away. So we're going to talk about, without much ado, we're going to talk about this question that I get. Can I still get my green card even though I'm divorced from my spouse who is a U.S. citizen or green card holder, or I'd like to get a divorce. The marriage is not working out. It's nobody's fault. It's just not working out. Can I still get a green card? So let me backtrack so that I give you a full picture. So when you're married to a U.S. citizen or a green card holder and they file a petition for you, if it's an adjustment of status petition, you're in this country, right? You get, you're in the United States, you get a conditional green card. So you go for your interview, your marriage interview, and you get a conditional green card. And why do you get a conditional green card? You get a conditional green card because at the time you're married, your card was approved, you were married to your spouse for less than 2 years. So that conditional green card, also known as a temporary green card, is only good for 2 years. To get a permanent green card, you have to remove the conditions on the green card. So you have to remove that conditions 90 days before the green card expires. So on the second anniversary of the green card, 90 days before might be a really great time to put your paperwork in with your spouse. You're supposed to do it jointly with your spouse to remove the conditions. When you remove the conditions, you should expect to get an interview. Now, there's a new law that came into place, a new policy guidance that says that USCIS is really looking to only have interviews for cases that fit certain types. So if you're lucky, you might not even get the second interview to remove the conditions on your green card. So your plan is to prepare your petition in such a way so that you can avoid that interview, because the I-751 waiver interviews are really, really, really tough. So basically, if USCIS looks at your looks at your case, your submission, the I-751 form, which is what the form you submit to remove the conditions, and they see that it's credible, it looks like the marriage was real or it was entered into in good faith, and you put in all your evidence showing that it was entered into in good faith, they may not give you an interview. You may just get your green card in the mail, which is really, really awesome. And the reason for this is because USCIS is so backlogged. I know all of you who have immigration petitions are aware of this. They are so backlogged. So they're looking for ways to make it easier for themselves to catch up on the backlog. And one of these ways is to only interview cases where they need some persuasion, I guess, that it is a real valid marriage. So going back to the question, the marriage is not working out. We've tried, it's just not working out for many reasons. You want to get a divorce, but you're worried that you may not be able to get your green card, your permanent green card, because you're getting a divorce. Now, the good news is this: there are waivers, waivers to the requirement of a joint filing. So there are waivers you can self petition without your spouse in if you if you fall into four different categories. You can fall into one of them or several of them. So the categories are: number one, if your spouse, your US citizen spouse or green card holder spouse has passed away. Clearly, that shows that that person cannot jointly file. But you still need to show that it was a valid good faith marriage when you entered into it, which is the problem a lot of people who have come to my office have faced, because they feel that because their spouse has passed away, they can just show up and get a green card. No, you still need to show that the marriage that you entered into with your deceased spouse was a valid marriage. It was a good faith marriage. You married your spouse because you wanted to be with your spouse, not for immigration benefits, right? And sometimes that can be a little tough if maybe the marriage was a young marriage, maybe you're married for a month or two and your spouse passed. However, there are ways of showing a good faith marriage. You just need to think outside the box. So the second waiver is divorce. So I'm going to talk about this for a little while. If you're in a relationship and it's just not working out, right? And you want to file a divorce, clearly you're not going to ask your spouse to join the petition because you guys are no longer together. So sometimes the one scenario is you file the joint petition with your spouse, right? And then while you're waiting for the case to be adjudicated, the relationship packs up and it's not working anymore, and you now have to do it on your own. Well, you can. Or another scenario is you divorce your spouse, it's not working out, and you have to, self-petition on your own. You can do that too. But what you need to remember is this: if you're filing under the waiver of divorce, by the time you go for your interview, you must have a divorce decree. Now, typically, USCIS may actually even send you an RFE, because sometimes some divorces take a long time. It could be, that the parties are just not getting along and they're fighting over everything. Or it could be that the courts are so backlogged as well, and it just isn't, you haven't been able to get your divorce decree to come through at the right time. So what you need to know is if you're taking this divorce waiver, you're going to need to have a divorce decree. Otherwise, it will be denied. It will. Okay? So one thing you could do is if your court system allows you to have a rush process through the divorce decree, that might be something you could do. Or because it takes about, USCIS is taking about maybe 24 months to get to an interview. Sometimes they may send you an RFE, request for evidence, requesting that, and you might send something saying it's coming, we're going to get it. But honestly, if you're taking the divorce route, you want to try and get your divorce decree as soon as possible so that you can get your green card through the divorce waiver. Now, there are situations where you're in this relationship is not working out because there's been abuse or emotional cruelty, right? And you just can't do it anymore. And that's a good thing for you to know. You don't need to be in a bad relationship because you want a green card. The law says that you don't need to. So please get out of toxic relationships, get out of toxic marriages. You can still get your green card, but you just need to make sure that you follow certain guidelines. So if you're in an abusive relationship, physically abusive, emotionally abusive, it could be psychological abuse, it could be financial abuse. I think I talk about this a lot. This is almost like a VAWA, but in the case of VAWA, you never got your conditional green card, right? So some people interchangeably call it VAWA, even though it's I-751, because VAWA also has the components of extreme cruelty and or physical abuse, right? So sometimes I have clients who are filing under the divorce waiver, but the incidents that led to them getting a divorce was extreme cruelty and abuse. So we can use both waivers. And sometimes, even if the divorce decree doesn't come out at the time it's supposed to come out, we may be able to use just the waiver of the abuse to get the green card. So nothing stops you from using as many waivers as is applicable, right? So if the divorce waiver applies, use it. If extreme cruelty and physical abuse or physical abuse apply, use it too. So I typically would use both of them if my client is trying to file for divorce and at the same time has been subjected to extreme cruelty. So let's talk about what extreme cruelty or physical abuse is for a second, right? Now, if you have a spouse who's threatening to divorce you because they're telling you you're not going to get your green card without them, right? Or they're controlling you, or they're being verbally abusive, gaslighting you, hiding your documents. I know I've heard of people who will get a PO box, that is American citizens or green card holders who will get a PO box so that their spouse don't have access to immigration mail when it comes in because they want to be in control, right? If you've suffered abuse, right, where your spouse is embarrassing you in front of people, putting you down, controlling you, not letting you go out, not letting you talk to people, um, threatening to call authorities on you, threatening to call the police on you, telling you that no one's going to believe you, or they're making you go to work and taking your money, or not working and not contributing to the bills and all of this stuff. I mean, I've talked about abuse and a lot. So, but remember, I always say this: abuse does not stand on its own. In all these cases, you must show it's a valid marriage. You must always show it's a valid marriage, because just being abused does not qualify you to file another waiver. You still have to show it was a relationship, a marriage that you entered into in good faith. So that is the third criteria, right? Cruelty or extreme abuse, right? Extreme cruelty or physical abuse. Now, the fourth waiver is extreme hardship. If leaving this country and going back to your country will cause you extreme hardship, right? For instance, say you're from a country like Ukraine. There's a war there. It's going to be really bad if you had to go back there, right? Or you're from Cameroon. One of any of these countries with TPS. You may be able to show extreme hardship that it's going to be hard for you to go back to your country based on the crazy things that are going on in your country. Or maybe it could be based on some really, maybe you have a health condition that cannot be treated in your country. Basically, what is the extreme hardship you would suffer if you didn't stay in the United States? So those are the different waivers that you can use to get your green card. Now, let's talk about the filing, right? So to file for your removal, you file either jointly with your spouse or by yourself. If you're doing the waiver, you file the I-751, right? And you include the filing fee, and then you put in the evidence of a bona fide marriage. Now, you want to put in information. Don't give them back the same information you submitted the first time. You want to show them or give them information from the time you got your green card, the conditional green card, to whenever it is that the marriage ceased to be a good marriage. You want to show that it continued to be a good marriage until it wasn't. Now, the good thing about using the waivers is that you don't have to wait until the 2 years, until 90 days before the green card expires to file your waiver if you're doing it on to file your removal if you're doing it under a waiver. If you're filing with your spouse, you do have to wait until 90 days before the second anniversary. But if there's a reason to file a waiver because either you're divorced or you're suffering extreme cruelty or physical abuse, you don't have to wait. Or your spouse dies, you don't have to wait. Whenever that incident happens, you can just file your I-751 right then. So that's really great. You don't have to wait for the 2 years, right? Now, there's a scenario that happens, where, once you file the I-751, you get the receipt, right? And the receipt extends your green card for another 24 months. And the receipt says it's extended from 24 months from the expiration of your green card. But what if you're in a situation where maybe you didn't file on time? So maybe your green card expired a year ago, 2 years ago. So the 24 months extension basically keeps is not doesn't really extend it to the current date. So it looks like, you have a letter that does not extend your green card. What do you do then? So what you need to do is to take your passport, take the extension letter, and go to your field office and get the I-551 stamp. So that stamp is a valid, validates your green card, because it's, they stamp it as of the date you went in there. So another thing is, I know people get nervous that they haven't filed their removal and it's been maybe years, and they're thinking, well, I'm out, I'm late. What do I do? Well, the law requires late filing. It does. They just require you to give a reason, good cause as to why. It could be financial, it could be, health reasons, or whatever it is. Give a reason why you're filing late. I had a case where my client actually was 8 years late in filing the removal, and we were still able to get her green card because we had a reason for why it took so long. It had to do with the abuse that she suffered in her relationship, and we filed it 8 years later, and she got her green card. Right. So if in doubt, just go ahead and file. And I would suggest that if you're filing, you really want to do it right the first time. So get an attorney. Now, another thing to note is, if you have a conditional green card, you don't renew it. You remove the conditions, because I've had people who file the I-90 to renew the conditional green card. The conditional green card is not renewable. You have to remove the conditions. Only the 10-year green card is renewable. So that's a tip that you guys, something for you to know. So now, the reason why we ask you to file your the removal of your conditions as soon as you're supposed to, at least by the second anniversary of your marriage, when 90 days before the green card expires, is because you don't want to get sent to immigration court. Because typically, if you do not file your I-751, you run the risk of being given an NTA, which is a notice to appear. So you don't want to do that. Now, if that happens, that doesn't mean you're not going to get your green card. It just complicates matters a little, slightly. Okay. So hi, let me talk to people on here and see what the questions are. Aderonke Saka. Hi, Aderonke. Thank you for joining my live, and thank you for appreciating the work we do here. So now Stephen Miller says, I got married June of last year, and my wife filed the package I-30, I-485, I-through on the work permit and my medical. I did by biometric in December, but I did not have time to gather a lot of evidence, but I have not heard anything since December. Well, Stephen, as long as when you filed the petition, you got the receipts, right, which shows that USCIS received it, right, then that's fine, right? Now, the work permit is taking about 8 to 10 months for you to get. So if you filed last year, June, well, it's about 8 to 10 months. So you should be getting a work permit if you haven't gotten it now. And with regards to not having heard anything from USCIS, it's typical because they're really backlogged. So something you might do might be to give them a call in the mornings, their 800 number, and, find out what is going on. But honestly, the scenario you paint is normal. USCIS is taking a long time to go through this stuff. So as long as you got a receipt notice and the check was cashed, it means that they received it. Just wait on that. Maybe in the next couple of months, you probably would get your work permit and I-131. If you don't, and they require something from you, they will send you a request for evidence. All right. So I think that's pretty much it. That's what I wanted to talk about today. But another thing I want to say is, if you're in immigration court for whatever reason, please do not travel. Because when you get your I-751 receipt, the extension letter, you can travel with that as long as the dates are still valid. And if it's not, like I said, go get the I-551 stamp, and you should travel with that. If you're in immigration court, please do not travel, okay? Because that leads to a lot of complications. So it was nice talking to you guys today. I will sign off now because I have to get back to work, but I will try to come back again sometime, a couple of times this week. Okay. So, like I said, subscribe, like, so that when I come on, you are notified. Thank you guys. And it's have a great week.